Commission on Elections, Power and Functions. Number 1. Enforce all laws relating to the conduct of election, plebiscite, initiative, referendum, and recall. What is initiative? It is the power of the people to propose amendments to the Constitution or propose and enact legislation through an election called for that purpose. There are 3 systems of initiative. 1. Initiative on the Constitution. 2. Initiative on statutes. And 3. Initiative on local legislations. Referendum. What is referendum? The power of the electorate to approve or reject legislation through an election called for that purpose. There are 2 classes of referendum. 1. Referendum on statutes, or 2. Referendum on local laws. Under RA 6735, Section 30, Section 3, subsection C. Recall. What is recall? It is the termination of official relations of a local elective official for loss of confidence prior to the expiration of his term through the will of the electorate. And lastly, plebiscite. Plebiscite is a submission of constitutional amendments or important legislative measures to the people for ratification. Next, power and function of COMELEC. Recommend to the Congress effective measures to minimize election spending and to prevent and penalize all forms of election frauds, offenses, malpractices, and nuisance candidacies. 3. Submit to the President and the Congress a comprehensive report on the conduct of each election, plebiscite, initiative, referendum, or recall. 4. Decide administrative questions pertaining to election, except the right to vote, the jurisdiction of which is with the judiciary. Power to declare failure of election. The COMELEC may exercise such power motu proprio or upon a verified petition, and the hearing of the case shall be summary in nature. From the case Sison v. COMELEC, 1998. 5. File petitions in court for inclusion or exclusion of voters. 6. Investigate and prosecute cases of violations of election laws. Note that RA 9369, Section 43 thereof, of the Automated Election System Law of January 2007 grants the Department of Justice concurrent jurisdiction to investigate and prosecute violation of election law. However, COMELEC may validly delegate this power to the provincial fiscal. From the case of People v. Judge Basilia, 1989. 7. Recommend pardon, amnesty, parole, or suspension of sentence of election law violators. 8. Deputize law enforcement agencies and instrumentalities of the government for the exclusive purpose of ensuring free, honest, orderly, peaceful, and credible elections. 9. Recommend to the President the removal of any officer or employee it has deputized for violation or disregard of or disobedience to its directive. 10. Registration of political parties, organizations, and coalitions and accreditation of citizens' arms. And 11. Regulation of public utilities and media of information. While COMELEC cited the Constitution, laws, and jurisprudence to support their position that they had the power to regulate the tarpaulin, however, all these provisions pertain to candidates and political parties. COMELEC does not have the authority to regulate the enjoyment of the preferred right to freedom of expression exercised by a non-candidate. Regulation of election paraphernalia will still be constitutionally valid if it reaches into speech of persons who are not candidates or who do not speak as members of a political party if they are not candidates, only if what is regulated as declarative speech that, taken as a whole, has for its principal object the endorsement of a candidate only. The regulation 1. Should be provided by law. 2. Should be reasonable. 3. Should be narrowly tailored to meet the objective of enhancing the opportunity of all candidates to be heard, and considering the primacy of the guarantee of free expression. And 4. Demonstrably the least restrictive means to achieve that object. The regulation must only be with respect to the time, place, and manner of the rendition of the message. In no situation may the speech be prohibited or censored on the basis of its content. From the case Diocese of Bacolod versus Comelec, 2015. Note, this power may be exercised only over the media, not over practitioners of media. Thus, a Comelec resolution prohibiting radio and TV commentators and newspaper columnists from commenting on the issues involved in the forthcoming plebiscite for the ratification of the organic law establishing the CAR was held invalid. From the case Sanidad versus Comelec, 1976. Lastly, of the power of the Comelec is power to decide election cases. The Commission on Elections may sit en banc or in two divisions and shall promulgate its rules of procedure in order to expedite disposition of election cases. Section 3, Article 9C. Cases which will be heard by division. Number 1. All election cases involving pre-proclamation contests originally cognizable by the Commission and the exercise of its powers under Section 2, Subsection 2, Article 9C. Pre-proclamation contests or controversies are election cases which are instituted prior to the proclamation of the winning candidate. They are deemed to be still in the administrative stage. It includes the questions of 1. Legality of the composition of the Board of Canvassers, and 2. Questions of fraudulent election returns, such as 1. An election contest, on the other hand, only occurs after the proclamation of a winner. Only after a winner has been proclaimed can there be an actual contest, with the contestant who seeks not only to oust the intruder but also to have himself installed in office. 2. Jurisdiction over a petition to cancel a certificate of candidacy. And 3. Even cases appealed from RTC or MTC have to be heard and decided in division before they may be heard en banc. If the Comelec exercises its quasi-judicial functions, then the case must be heard through a division. Upon motion for reconsideration of a decision, the case is heard en banc. From the case Manzala versus Comelec, 2007. If Comelec exercises its administrative functions, then it must act en banc. From the case Bautista versus Comelec, 2003. A motion for reconsideration or a decision. A motion for reconsideration of a decision or resolution of the Comelec en banc or of a division may be granted upon vote of a majority of the members of the en banc or of a division, as the case may be, who actually took part in the deliberation of the motion. If the voting results in a tie, the motion for reconsideration is deemed denied. From the case Legazpi versus Comelec, 2016. What is the composition of Comelec? There shall be 1 chairman and 6 commissioners. Qualifications. 1. Must be natural-born citizens. 2. At least 35 years of age. 3. Holders of a college degree. 4. Have not been candidates in the immediately preceding election. And 5. Majority, including the chairman, must be members of the Philippine Bar who have been engaged in the practice of law for at least 10 years. From Section 1, Article 9C of the Constitution.